A lot of us probably struggle with sleep hygiene, how to fall asleep, stay asleep, and get restful sleep. But did you know that improving your sleep hygiene could help improve your overall health? Health Break, a podcast by UPMC Health Plan, dives into this topic with advice and tips you can use from our expert wellness health coaches. Listen now to find out how you can start improving your sleep at upmchp.us/healthbreaksleep. That's upmchp.us/healthbreaksleep.
The independent state legislature theory was the centerpiece of the efforts to overturn the 2020 presidential election.
Hi, and welcome to Amicus. This is Slate's podcast about the courts and the law and the rule of law in the Supreme Court. And we are coming to you on a Tuesday this week with a special bonus episode because in a rather remarkable 6-3 decision Tuesday morning, the U.S. Supreme Court handed down Moore v. Harper, one of the most important cases of the 2022 term. Here on Amicus, we are offering all of our emergency episodes to all of our listeners rather than hiding them behind a paywall as Slate Plus member exclusives. We do that because we want to make sure that we are sharing this vital news of the court with as wide an audience as possible, but these emergency episodes are outside the paywall for a limited time, which is another reason to subscribe to Amicus so you never miss an episode, and another reason to maybe consider joining us at slate.com/Amicus Plus. Memberships are powering all of the work that we are doing here at the magazine, and we thank you, members, for your support. So, Moore v. Harper was a challenge to a North Carolina state Supreme Court ruling about a gerrymandered electoral map. On Tuesday, the court, in an opinion authored by Chief Justice John Roberts, resoundingly rejected the, quote, independent state legislature theory that had been pushed by state Republicans. That theory would have given state legislatures virtually unchecked, or what we in the law call plenary power, to draw new redistricting maps and to pass all sorts of restrictive voting laws. And it would have done away with the possibility of review of those actions by state courts or other entities. Quote, the Elections Clause does not vest exclusive and independent authority in state legislatures to set the rules regarding federal elections, end quote. Chief Justice Roberts writes in the 6-3 opinion, resolving a question that many believed the court never should have entertained in the first instance. Now, before this case was heard, we spoke to Judge Michael Luttig about what it all signified. He stood as perhaps the single most prominent critic of the entire proposition that review of a state legislature's election decisions was fundamentally impossible. He also stood as absolutely clarion clear that the idea that animated efforts of the Trump team to set aside the 2020 election were similarly just rooted in terrible, terrible legal thinking. Judge Luttig has testified to this effect, and when the case was argued in December, he called it, quote, the most important case for American democracy in the nation's history. If you're in the mood for more Luttig, his great essay in this week's New York Times is titled, It's Not Too Late for the Republican Party. Judge Michael Luttig was appointed by George H.W. Bush and served on the U.S. Court of Appeals for the Fourth Circuit from 1991 to 2006. Before that, he served as Assistant Attorney General in charge of the Office of Legal Counsel in George H.W. Bush's Justice Department. He was sworn in on the Fourth Circuit at the age of 37, at the time the youngest federal appellate judge in the country. Judge Luttig, welcome back to Amicus.
Dahlia, it's really my pleasure to be on with you today. Thank you for having me. Today's landmark decision by the Supreme Court was a resounding and reverberating victory for American democracy. You mentioned in your opening that many believe the court should never have taken the case. I always believed, actually, from December 2020, when the court denied review in the electors clause cases, that the Supreme Court had an affirmative obligation to decide the independent state legislature question, which it did today.
So I don't want to belabor the backstory. I'm guessing at this point most of our listeners know it, but the very short version is that in 2021, North Carolina lawmakers redrew their maps. The state had 13 districts at the time, more or less evenly divided voters between Democrats and Republicans, but those who controlled the process drew maps such that there were 10 seats to favor themselves. We had a panel of 3 trial judges founding that the maps were intentionally and carefully designed to maximize Republican advantage. The state Supreme Court struck down the maps under the North Carolina Constitution, guarantees of free election, free speech, free assembly, equal protection. North Carolina Republican lawmakers appealed under this independent state legislature theory, arguing that the Constitution doesn't give state courts any authority to pass on congressional maps. That's about the scope and size of what came to the court. Am I right about that, Judge Luttig? And if I am, I wonder if you can give us the backstory to the backstory, which is the sort of genesis and contours of the independent state legislature theory.
Yes, Dahlia, that's the politics of it and the procedure of the case as it arrived at the Supreme Court of the United States. The backstory really begins with Bush versus Gore and the court's decision in that case. In that case, Chief Justice Rehnquist, joined by Justices Scalia and Thomas, authored a concurring opinion in which they raised the specter of an independent state legislature. They did not denominate it as such, and nor did they put much flesh on the bones of that theory of theirs. And then last, the issue arose in Bush versus Gore in the context of state legislative provisions, not state constitutional provisions, which are at issue in the independent legislature theory decided by the Supreme Court of the United States today. So from Bush versus Gore, fast forward to the 2020 presidential election, and long before the election, the former president and his allies began to argue for the so-called independent state legislature theory of interpretation of the electors clause of the Constitution. And those litigations were initiated in several of the states, and they wound their way to the Supreme Court of the United States. And finally, it was in the first or second week of December of 2020 that the Supreme Court decided against taking the cases and therefore against deciding the independent state legislature theory. In my view, everyone could see, not even foresee, they could see at that point what the possibilities would be on January 6th if the court did not take this case. Because the independent state legislature theory was, I've called it the centerpiece of the efforts to overturn the 2020 presidential election. Notwithstanding that, the Supreme Court refused to hear the case, notwithstanding that there were a number of the justices at that time who had already expressed interest in the issue. So there was never any question in my mind or those who follow the court closely that having refused review right before the 2020 election, that the Supreme Court would have to decide the independent state legislature issue soon, and it chose to do it in Moore versus Harper, which arises not under the electors clause, but rather the elections clause of the Constitution. That's the background.
I'm so glad that you're doing this work of lashing, what you're describing as this very political case in North Carolina to what was going on around the attempts to set aside the 2020 election, because I think it's easy to see those as happening fully independent of one another. And as you note, they're sort of intricately connected. But I wondered if one of the things that you have been saying, I think from the jump, Judge, is that, the independent state legislature had, I think your quote was, literally no support in the text of the Constitution, that the folks who were doing it were also doing bad history. And in a sense, it feels as though what the Chief Justice resoundingly does today is re-up the idea that if we're going to do text and we're going to do history, then let's get those things right. And it does feel like this project of textualism, of original public meaning, of originalism also gets a boost today, because this idea that you can import your own views of text and your own views of history into the discourse kind of gets slapped back today, right?
Yes, to a fare thee well, Dahlia. Let's take the textual point first and then the history point second. As to the text, when I came into the case, frankly, all parties, all sides of the case were arguing the case from the text. So, for instance, the petitioners argued that the text, because it empowered the state legislatures to prescribe the rules, argued that, therefore, the state courts could not second guess in any way that decision. For their part, the respondents, though, walking right into the textual argument themselves, argued that, yes, the text actually decides the case, but the text tells us that it's the entire legislative process, lawmaking process, that's empowered to make the decisions. That is, that judicial review was part and parcel of the legislative function that was enacting the laws governing redistricting. And I didn't just think it. I knew that was it was categorically wrong, and that, frankly, both sides were categorically wrong. And that's why I ended up writing the pieces in The Atlantic before I agreed to be co-counsel for Common Cause with Neil Katyal. I wanted to stake out what I was confident at that point was the law on the textual side. Then if we turn to the history side, I did all of the research myself, and thinking about the research from the entire body of research that had been done by everyone else. I didn't do the original research, in other words, but when I studied that at great length, it was crystal clear to me, without any question whatsoever, that the history compelled today's conclusion. Specifically, that long before the founding and the ratification of the Constitution, state legislatures had under their own constitutions played a very active role in the legislature's promulgation of the rules governing both federal and state elections. So, and that was an uninterrupted practice from before the Constitution's ratification until today, frankly. And that's what the Supreme Court, in Chief Justice Roberts' opinion, validated today.
Stay right where you are. We're taking a quick break.
Hey there, Amicus listeners. It's Mary Harris from over at Slate's Daily News podcast, What Next? What Next is a show we make to help you grapple with this question. How do you keep paying attention to the news when it feels like the news is stuck? You know what the Republicans are going to be saying. You know what the Democrats are going to be saying in return. You probably even think you know how you're going to feel about all of it. My short daily podcast is here to help you make sense of things, even surprise you, from fleshing out new angles to uncovering stories that have largely gone unreported. When the news feels a little predictable, I'm here to help you answer what next. So subscribe wherever you're listening right now.
Hey there, Amicus listeners. If you like this show, you should really check out The Waves from Slate. The world can feel overwhelming right now. Everyone is always yelling, there's too much TV to find anything good, and who knows what is going to happen with the climate. Luckily, there's The Waves. Every episode, you get a deep dive into a topic we can't stop thinking about. From what the E. Jean Carroll victory means for women, to protecting kids from diet culture, to making movies horny again. If you're thinking about it, we're talking about it, and unpacking what gender has to do with it. Listen to The Waves from Slate, wherever you get your podcasts.
Let's head back to my conversation with Judge Michael Luttig on Moore versus Harper. You mentioned that members of the court had evinced historically at least some interest in the independent state legislature theory. I think Justices Alito and Gorsuch and Thomas had at least looked as though they were in favor of some version of it. And Justice Kavanaugh, again, had indicated he was at least open to thinking about it. The dissenters today are Justices Alito, Gorsuch, and Thomas. Now, part of that, they think that the case should have been dismissed as moot because the North Carolina Supreme Court flipped in the intervening period. In some ways, the case went away. You noted that it was important that they resolve it anyway. But it does seem to be the case that Justices Alito, Gorsuch, and Thomas were open to the more maximalist version of the theory being pushed, correct?
I don't know that we can say that, Dahlia. I think that what must be said first is that never before had the court or any of its justices in prior courts been presented with this version of the independent state legislature theory. So when they had commented previously, including the comments by Chief Justice Rehnquist, Scalia, and Thomas, no one had been thinking anything like the argument that was made by petitioners in this case. So I for one, have never said that the Supreme Court had pre-decided the independent state legislature theory because I knew, in fact, that they'd never even thought of this. And I always thought, as you know, that when they were forced to think about it in the context of a specific case, they would reject it. In fact, at the risk of some slight embarrassment, internally, I said that based upon the argument only, that it was possible that there would be 9 votes on the Supreme Court to reject the independent state legislature theory as argued by petitioners.
Before we turn to what's coming next, because it's important, I wanted to give you a chance to respond to a couple of folks who say this is a narrower victory than we think. I'm thinking of Rick Hasson, Richard Pildes. A couple of folks said, actually, no, because the court actually signed off on some version of that minority Rehnquist position in Bush v. Gore that you opened with, and that arrogates unto the court at least some decision-making power going forward, that there's going to be more judicial review to the federal courts and especially the Supreme Court itself. And I think what Rick Hasson is warning is that means that while it's true that, we're not going to carve state courts out of the picture, and as you note, that was never really a plausible reading, we don't know the contours of the power that the Court arrogates to itself, we're going to have to wait and see. Do you disagree with that version of it, which is the big winner today in some sense is the Supreme Court because they will get to pass on future election laws? And ironically, this is in some sense Justice Thomas's dissent. We don't know the scope of that power going forward.
The Supreme Court today did not say that the state Supreme Courts have free reign. What the court said is that the state Supreme Courts cannot arrogate to themselves the power of the state legislatures that's conferred in the Constitution on the state legislatures. It went on to say something to the effect that as long as the state Supreme Courts are performing their traditional judicial review of the state legislative enactments, then those courts may apply the state constitutional provisions as they would in any other context. So for your listeners, think of that as the court saying that the state Supreme Courts cannot themselves legislate, because the role of legislating falls exclusively to the legislatures. Now, this is a line that has been used to great benefit and purpose in these great discussions about the roles of the various branches of government. It has meaning to all of us, but it doesn't have legal meaning. So I took this issue on in one of the Atlantic articles and actually said essentially what I just said to you, that this has served a great purpose, but it's meaningless in application. I said there that every time that a court decides a case, it is performing the judicial function, and it is never performing the legislative function. Therefore, the Supreme Court of the United States could never use that standard for deciding whether state courts had overstepped their bounds. The Supreme Court effectively said that today and laid that down as the standard. That will not be the standard that's applied going forward. The next case, the Supreme Court will have to decide the actual legal standard, if any, that it wants to apply in its review of state Supreme Court decisions that are passing on the state legislature's redistricting decisions.
And that's what I think Justice Kavanaugh struggles with, right? In his concurrence is we're going to try to figure out what that standard is, but we certainly don't know it as yet.
Let me say to that, Dahlia, because this is where I have done the lion's share of my thinking from day one on this, as to the standard of review. Okay, I was the first person that I know of to write that the Bush versus Gore standard is simply inapplicable in the context of reviewing state Supreme Court's applications of their own constitutional provisions. Because, as I said at the top of your show, Bush versus Gore was looking at the question of state statutory questions. And state statutes, just like federal statutes, they're detailed and they're prescriptive in their detail, in contrast to both federal and state constitutional provisions that are expansive and general in their application, such as the Free Elections Clause provision of the North Carolina Constitution that was applied here in Moore versus Harper to invalidate the redistricting map. So I'm as confident as I can be that the standard suggested, the court did not articulate a standard today. That's very important to note. But the standard that it suggested, the one that I just paraphrased, will not be, at the end of the day, the standard that the Supreme Court adopts.
Let's take a quick break. Have you been keeping up with the ways we're working to create a new type of Supreme Court coverage here on Amicus and at Slate Magazine? Get up to speed at slate.com/opinionpalooza and help support our work when you become a subscriber to Slate Plus. And thank you so much to our Slate Plus members for making this coverage possible. Now let's return to my conversation about the big democracy case, Moore v. Harper, with Judge Michael Luttig. Can we end with a reflection from you on Donald Trump and his connection to the decision in Moore v. Harper? Because in some sense, and you opened with this, and I think you've spoken so eloquently to this in the last weeks and months and years, it was, in some sense, the green light for so much of what happened around January 6th.
The independent state legislature theory, Dahlia, was the centerpiece of the former president's effort to overturn the 2020 presidential election, without any doubt. And it's an intractable question, as evidenced by the fact that only the Supreme Court could decide it, which it did today. But in the 24 hours that I advised the former Vice President Pence as to his obligations on January 6th, I had to do the best I could to come to a decision of what I thought about the independent state legislature theory. And in short, in that 24 hours of researching and thinking about it, I concluded that there was nothing to it whatsoever. And that was in the face of the former Chief Justice's concurrence in Bush versus Gore. So fast forward to the 2020 election, and Trump and his allies argued for it. They didn't get it, but neither was it rejected by the Supreme Court of the United States. Today, for the first time, it has now been rejected. The implications of the Supreme Court's rejection today of the independent state legislature theory are enormous for the continuing investigations by the Department of Justice, the Attorney General, and Jack Smith into the former president's and his allies' conduct on January 6th. Today's decision knocks the props out from under what would have been one of their principal defenses to charges of wrongdoing on January 6th.
Judge Michael Luttig was appointed by George H.W. Bush, served on the U.S. Court of Appeals for the Fourth Circuit from 1991 to 2006. As he noted just now, it was Judge Luttig that Vice President Pence turned to try to sort out on the fly the parameters and possibilities of the independent state legislature theory. And as he did then, he does again today, makes that which is very, very impenetrable and abstract abundantly crystal clear. Thank you, Judge, for your time today.
Thank you, Dahlia.
And that is a wrap for this episode of Amicus. Thank you so much for listening in, and thank you so much for your letters and your questions. You can keep in touch with us at amicus@slate.com, or you can find us at facebook.com/amicus-podcast. Today's show was produced by Sarah Birmingham. Alicia Montgomery is Vice President of Audio at Slate, and Ben Richmond is our Senior Director of Operations. We'll be back with another episode of Amicus very, very, very soon. But until then, hang on in there.